Is Nashville's district attorney office violating a state law that it's supposed to enforce? That's the latest question raised by our News Channel 5 investigation. Good evening, everyone. I'm Rory Johnston. And I'm Carrie Sharp. At the center of that investigation, questions about listening devices that could secretly capture conversations of people visiting DA Glenn Funk's office. In recent months, our investigation revealed how Funk paid a part-time employee $75,000 a year with little evidence of what that man did for the money. Yeah, we also raised questions about DA employees working to get the boss reelected, taking that time off from work only after we began investigating. And we discovered that Funk gave up $354,000 to prosecute drunk drivers. The DA refuses to say why. Well, News Channel 5 Chief Investigative Reporter Phil Williams continues his investigation.
Both federal and state wiretapping laws make it a crime for you or I to set up devices to intercept other people's conversations. In this case, Glenn Funk's office says what they are doing is necessary security, but some experts tell me it could cross a line. You're waiting for an elevator, chatting with a friend, or perhaps you've stepped out of an office to take a call. Would it ever occur to you that your conversations were being recorded? For months, insiders at the Nashville DA's office had raised concerns about security cameras, also capable of secretly picking up conversations of people visiting the office as well as employees, along with allegations of one official inside the office who routinely listens to such chatter. For months, Nashville DA Glenn Funk's team had refused to produce videos and audio requested by News Channel 5 Investigates from their own office security system that might help answer those questions, citing an exemption in state law that protects disclosure of information related to building security. But then a breakthrough. The company that installed the security system confirmed the existence of eavesdropping devices in areas of the downtown office building controlled by the DA's office. Cameras equipped with microphones capable of picking up conversations in the elevator lobbies outside DA offices as well as inside the office's main lobby. The company's owner explained, "We don't put audio on a camera unless they specifically ask for it." In fact, we obtained invoices where the DA's office ordered 2 cameras with audio capability and a network video recorder for an undisclosed location, along with an invoice for a 3rd camera with a built-in microphone. That 3rd camera was ordered just days after the controversial plea bargain of police officer Andrew Delkey in the shooting death of Daniel Hambrick. The security company says the DA's office wanted to be able to eavesdrop on protesters who might come to the office. One of those cameras, the company confirmed, is on the 4th floor where the Davidson County grand jury meets, meaning conversations of witnesses, defense attorneys, even grand jurors themselves could also be intercepted as they wait for an elevator. In a written statement, the DA's office said security for law enforcement offices is imperative. The district attorney's office is located in a building open to the public. The law is clear that there is no reasonable expectation of privacy for conversations in public places.
A person who tries to record something privately, no matter what the motivation is violating the law.
Former federal prosecutor Gary Blackburn notes that both federal and state wiretapping laws make it a crime if a person intentionally intercepts, endeavors to intercept, or procures any other person to intercept any oral communication. The key question, Blackburn said, is do the people whose conversations are being recorded have a reasonable expectation of privacy?
What we're trying to protect with federal and state wiretap laws is the ability to have a private conversation. And where you are is less important than the sense of privacy.
So if you have a reasonable belief that this conversation is private, then it cannot be recorded.
That's correct.
The company that installed the security equipment told me that the people who lease space to the DA's office should have a sticker at the front door warning visitors that their conversations are likely to be monitored, something that at first glance we didn't see. But if you go down to your knees, it's there, although it's not clear how many people would be willing to go this far. And on the floors where DA offices are located, there are signs warning about video surveillance, but no hint that this camera is recording every word we say. Is it enough to put up a sign saying that video surveillance is in progress?
No, because video surveillance would not necessarily imply audio surveillance.
We go in a lot of places where there's video cameras. We see that all the time.
Jonathan Cooper is past president of the Tennessee Association of Criminal Defense Lawyers. He worries about the implication of defense lawyers being secretly recorded outside of meetings they might have at the DA's office.
It's very common for defense lawyers to go with associates or co-counsel or investigators, or sometimes even with clients. And if there is the perception that those conversations that are occurring in the common areas could be monitored, that's going to have a very chilling effect.
And inside the criminal court building, we discovered an office where defense attorneys come to review police body cam video that's also wired for eavesdropping. We waited for the door to open. Inside, we spotted one of the cameras up in the corner and a sign warning that the premises are, quote, protected by 24-hour audio and video surveillance, that anyone who enters consents to being recorded.
Frankly, it's a betrayal of trust.
While it's not known how long that sign has been there, Jonathan Cooper questions why the DA's office even feels it needs to eavesdrop on defense attorneys as they review evidence.
There is a level of trust required in a working relationship between defense lawyers and prosecutors. This would certainly be perceived as a betrayal of that trust.
We sent General Funk several questions, including how have these recordings been used? Unfortunately, we did not get an answer to that question, only the statement that in their view, people who come into their building have no expectation of privacy, and as a result, any conversations in public areas can be recorded without their consent. Phil Williams, News Channel 5 investigates.